everyone. Welcome back to Parallel Barking. I'm Ariana Backer, and I'm here, bark bark, with my co-host,
Woof woof.
Larry Backer. And we're going to talk about something that has gotten a lot of attention in the past few days, and rightly
You
so.
should mention we are going to talk about it again.
Again.
The first time we talked about it,
it
was leaky.
It had been a leak, but now it is set in stone, so to speak.
But that's the point of the case, isn't it? There's no stone anymore. We're talking about the abortion decision.
Right. Roe versus Wade, or actually the actual case. Yes, the Dobbs. That's one thing that I want to talk about first. It's very confusing.
All right, go ahead.
But anyway, the Dobbs versus Jackson Health Clinic case.
Everyone knows it as the abortion case.
As the abortion case.
It's going to go down in infamy as the
case that overturned Roe versus Wade or Roe v. Casey. Both.
No, Roe and Casey.
Roe and Casey.
Roe being the germinal case.
Oh, yeah. It wouldn't be Roe v. Casey. Roe and
right.
Casey.
Right.
So
what's on your mind besides a tremendous amount of anger? That's everywhere. There's anger and jubilation and anger and plotting. So what's on your mind?
Why?
Well, there is plotting. I mean, this is a political case. It's a moral case. And politics this isn't like going to a sermon in a church and being either enraged or uplifted. This is politics.
Well, yeah. And
so what's got your goat?
Is
that an expression?
Hilarious that throughout the opinion, the justices were trying to convince either themselves or whoever is going to read this that this has nothing to do with their own morality or their own beliefs about.
Well, but justices have been doing that since the year zero.
Yeah.
So what's the big deal? I mean, why?
What is the big deal, right?
Why get yourself all in a bunch about that? Now it's 200 years too late. We have to accept it that indeed that's the case, and that what we have to worry about is not that in fact they aren't human beings are victims of their own desires, but whether there are institutional limitations or social or cultural limitations that make them at least think 3 times before they indulge themselves to the point where it makes a mockery of the judiciary.
Well,
and
yeah,
you're right.
That's my
in
question.
This case, it's not clear that there were very many stops.
So there were, I guess, 3 pillars that they based their decision on.
Are you really interested in the way they did this? I thought you did.
Was.
Okay, go ahead. So
you're
a lawyer and you're not, and you're worried about the inside of the case. And as a lawyer, and this is really horrible, I'm going to lawyer hell for this. I don't care. It's the political aspects of the case that are far more interesting to me rather than what becomes gibberish in a sense. This is where we are in 2022. The justices have over the last 70 years worked themselves into a corner of gibberish.
Yes.
Where the only people who can understand what they're saying is this small cadre of elites who then work their magic on a population that then becomes dependent on them. So in a sense, what you're looking at in the Dobbs case is a dose of fentanyl and being pushed by a bunch of people who now control its supply for people who can't get enough of this, and eventually we're going to overdose. But okay, you want to talk about the case? Let's talk about the case.
Okay, now I really don't.
But no, go ahead. Everyone.
It's really because of my lack of understanding and my I guess my.
Well, shoot. What is it? To apologize, no one can understand this stuff, and that's the problem.
It's not that I don't understand what he wrote. It's my I guess I am aghast at how
aghast. I like that word.
Aghast at how flimsy this argument is in comparison
in
to
your mind. In your mind, I mean, in the minds of the people who wrote it, it's not flimsy at all.
Well, right, because they believe that they are the smartest people in the world and they have the right to dictate. Yes, yes,
no,
yes.
they believe that they are burdened with this. Let me just give you the
yes, because they are the smartest people in the world and they must dictate to all of the plebes.
Please,
yes,
please, no one believes that, and certainly they don't. But they do believe that they are burdened with a responsibility that they're going to try to undertake to the best of their usually flawed abilities, which is okay. We're all humans and no one is perfect, including us, certainly. But what about it? Because there really is an A thing here. There are a number of
There are so many things.
So what's the one? Well, what's the one that got your goat? You said you had a number of very specific.
Okay, well, hold up. Okay, so going back through all of the history is fine.
History test. The history test.
The history test was fabulous.
Was it really? The Dissent. You got to reread the Dissent. The Dissent had a field day with the history test.
Right? No, I mean fabulous in the fact that it was like ridiculously hilarious. Are you freaking kidding me?
Well, you're gonna go except understand that the history test, when it suits the progressives as well as when it suits the conservatives, has been used. I can tell you, for example, that when we built the wall of separation between church and state,
this is all that I want to address. This whole system sucks.
Wait, no. Now you're being cynical and sad.
No, I'm not. It makes no sense.
Justices wax eloquent on history, and it's usually justices make bad historians, but really good political or strategic uses of history in the, again, to the best of their ability. They also love using social science, and they've been using social science certainly since Brown, and then they come to regret it because social science, whatever the understanding of the day, has a half-life of about 3 seconds. But they've been doing this for a long time. So in that sense, you can be angry about what you believe to be their misuse of history. Certainly from the dissent's perspective, there was misuse, but from the majority's position, the dissent is misusing history too. You can be mad about their misuse, but the court has been doing this both for the grand progressive building. Of course it has,
but my point
as well as for building this.
Why have we set it up so that we view? I mean, he's right. The opinion was written as if the Constitution is the Bible.
It is.
It is not the Bible.
It is the foundational.
I knew you were going to say this, and this is why I want to smack you.
Sorry. If you don't like it,
the Bible in that it can't be rewritten, right? We have amendments.
Go back to 1788. And
no. We have to be able to have this document so that we can have it evolve along with the people, right?
Why? Well, no. Why? That's a plausible reading of the document.
Right.
But it is not necessarily the only one.
Oh, so you want to be
I don't want anything.
A robot.
I do not want anything. So don't make this personal.
No. But
what I'm suggesting is that the problem that you are relating to in your anger, and is a correct one, is the fundamental. I teach this in my class.
And that's what I want to talk about. The fundamental issue, the problem.
The fundamental issue is an absolutely unresolvable ambiguity about the relationship between text and intent.
And there's no way we're going to solve that. This whole thing was about the substantive versus.
No. If you can't solve an ambiguity, then you have to at least develop ground rules where you can at least build some solidarity in the community around it.
Okay, and then precedent gets thrown away.
Right?
And then precedent gets thrown away. Well, what happens when that solidarity is broken?
They had this huge, now you want to move from the history test to the stare decisis. Well, stare decisis cuts in a lot of ways. I, for one, and just so that, let me put my cards on the table, I find the majority opinions rewriting of the principles of stare decisis to be less than satisfactory. My preference, and I think the sounder basis for stare decisis, was those principles enunciated in the Casey decision. I believe, as do most people, that there are some instances over a long period of time where it becomes clear that both the jurisprudence, society, and social understanding point to the initial and fundamental error of a decision, which then requires its abandonment, but
Yes.
that in most cases, you don't need to do that. And that indeed was Chief Justice Roberts' position in this case. Why are you going waxing eloquent about stare decisis and getting rid of this case when in this specific case, you didn't have to do this at all because you could just apply the current, it's basically a plain vanilla application of the current doctrine, and to find in this case that the Mississippi law is valid, or in dissent that
Yeah,
the
that was
Mississippi
my
law is
other
invalid.
point. Was
That's Justice Roberts' concurrence.
why was it decided that this was above and beyond that there was an absolute need to overturn previous precedent?
Because four of the justices, three of the justices at least, believed as a matter of their own notions of principle and the like, that the fundamental principle of federalism ought to trump the fundamental principle both of stare decisis and of the use of the Supreme Court to read constitutional text to protect the autonomy of women from incursions by government.
Well,
and
because
so they
also
made
believe
a value choice on the basis of their reading of history that federalism principle trumps, I love using that word every once in a while just to watch.
Okay, yeah, I want to smack you.
Sorry, it's a bad dad joke. All right, I know, and it's too soon. That federalism principles trump, because it is textual, trump the judicially developed or recognized, because I don't think it was judicially developed, it was merely judicially recognized later on in the constitutional history of this country, judicial principle of the autonomy of individuals in general and of women in particular in this case. That's the choice they made. Now, that's three people. Another person believes that the whole notion of finding or of recognizing rights, this is Justice Thomas's concurrence, which is worth reading and reading.
I know.
Is that in fact the entire exercise of extracting principles from text is invalid. His is the kind of very narrow textual historical analysis that you find most disturbing.
Infuriating.
Many people do, and yet
we use it. I mean, the progressive side uses it. Everybody uses it when it's to their advantage. I understand that.
Okay, but that's the problem.
I understand that. Yeah, it's always been the problem. I mean,
well, but it's been the problem that is insurmountable again because, and again, we really should do a podcast on basic semiotics because it is the fundamental problem of human collectives. When you have a human collective, where do you draw meaning from? What are its sources? What are its foundation? Is it a textual memorialization of the agreement to form a collective consent? Is it locked in time? Is it something that must be renewed with every generation? Or is text merely the gateway to intent, that is merely a memorialization of the actualized principle, which doesn't live in text, but is merely noticed in text? And so in order to figure it out, you've got to go through text to something else. For judicial minimalists, especially historical textualists, it is not only in text, but it is in text as they suppose some important segment of a historically stuck in time group believes. right? And so, for example, in interpreting the Constitution, it meant that the Constitution has to be interpreted the way it would be understood in 1788, pause, understood by whom? The frontiers people in the Kentucky Territory, the plantation owner in Southern Virginia, the exploitative ship owner or factory owner in Massachusetts.
And women didn't have an opinion, so they don't matter.
Well, but this is a problem for other people, right? Text is merely the memorialization of intent, and it's intent that is the principle that is memorialized in text. The principle as applied to a living community, applied in the context over time, right? But the principle stays, it's historically rooted, its application changes, right? So we understood over time, that's a very different way of looking at it, so that one could understand that the word equality.
Who solves that? How are we going to solve that problem?
No one.
Cool.
We go back and forth and people get frustrated. You can't solve that problem. And that's hugely frustrating. You can't solve that problem. But that creates a very different kind of problem here. And so you've got this problem with text and context, principle or history. And we went through all of this. We've got Justice Thomas, who's arguing that, in fact, the last 100 or 150 years worth of jurisprudence built on substantive due process really needs to be reconsidered. Not that it should be voided, but unless you can find some other textual basis that's historically contingent, then it ought to blow away. And then you've got three and ultimately four members of the dissenting group that says, no, we're going to apply the same techniques as the majority, except for us, the centering isn't the states. We're going to make a different substantive choice. We're going to privilege women's autonomy, and we're going to privilege, in this case, right, the sanctity of cases in jurisprudence, not so much cases in jurisprudence. For example, when we overturn 100 or so years of jurisprudence with respect to sodomy or contraception or
not yet.
No, but this is the dissent is saying, well, yeah, in this case, no. So but this is all fairly standard. A couple of problems though, and I want to talk about something else after we do this. A couple of problems. We've got a 213-page opinion. We've got a tremendous amount of words, and they're throwing, even as they are talking about historical reality and text, what they're really doing is slinging a bunch of old cases back and forth at each other. And so you've got a bit of, not hypocrisy, let's just say a bit of multi-level discursive operation here on a variety of different planes, all operating at the same time, which makes the cases far more interesting for the culture of judging and the world of the lawyer.
But that's what they do. That's what they've been doing for years, is what you said to me at the beginning of when we talked.
Right, but that gets me to my point. Is the court and the elite judges and lawyers who sustain this, and litigants and litigation groups that sustain this industry, are they doing the Republic a gross disservice by making these cases and its jurisprudence so impossible to understand that they become both irrelevant and dangerous? Ought they to reconsider, perhaps, that if in fact they are going to be steering the nation in very political and fundamental ways, that they should abandon this kind of medieval scholastic kind of thing for something else? And so, you can go and lawyers will spend the next 10 or 15 years parsing through the opinion. There's 213 pages of litigable words. They're going to find all kinds of arguments Law professors are going to make careers out of this. But I go yawn, because at the end of the day, all of that works well for the law industry and for preserving the closed loop power of a very small group of people who control the esoterica of these things. But it really doesn't help the 350 million people who now have to, whose lives are now going to be affected one way or another. So rather than talk about that, and we can, I'd rather talk, which is why I want to talk about anger. And I want to talk about action. At the end of the day, this is a political decision.
Oh, yes. No, first thing I want to say is I live in Washington State. And one of the things that immediately happened after or during was we started running ads. Hopefully, I think it was nationwide, that come and have a picnic in Washington State.
Absolutely.
You can enjoy picnics anytime you want in Washington State.
Right.
Picnics
And
are for everyone.
Right. So the question is what can be done? And from the perspective of people who find this opinion objectionable, and there are a whole lot of people who do for a variety of different reasons, right? And they don't all agree amongst themselves, but it doesn't really matter. How, in the face of a political opinion, how do you develop political challenge without going to court? Because the easiest thing now, and let me just say it and move on. The easiest thing to do here is to do what people have been doing more and more over the last 20 or 30 years, is that you begin to litigate this to death. And so you treat this case as absolutely narrow. It applies to Mississippi, right? And it applies to the specific context of Mississippi. So I would challenge every other statute, and I would just grind
let's create that history
to a halt, right? I would grind the courts to a halt by litigating everything, seeking injunctions, seeking to litigate, seeking declaratory judgment actions, finding people who are willing to put themselves in harm's way to litigate some of the actions. This is the first step. The second step is also legal, and we're already beginning to see this, for example, in California and Connecticut, and that is to develop state statutes that effectively, they're kind of like blocking statutes that make it illegal to prosecute or to execute judgments against people who have been prosecuted and on whom have been imposed civil or criminal or private fines or judgments for violating the abortion laws, and say that those things are not, they can't be executed in the state with respect to their property. You can have blocking statutes that says if a state, Missouri, I think, was a state that was going to do this in Texas, allowing private individuals to sue people who they believe are conspiring. California, I think Connecticut was going to do this, California maybe, is to say that if in fact you're sued under those statutes, you can sue the person who sued you, and you can recover your attorney's fees and whatever judgment was rendered against you in the other state, and that can be executed all over this. So you've got all of this litigation going on and statutory alternatives, but there are all kinds of other things that that people can do, from the political to the non-political. So let me start with the medical. So one of the things that, for example, the medical profession can do is start defining all kinds of procedures, defining the word abortion out of all kinds of procedures, so that what constitutes abortion as a medical term, right? And we're dealing with abortion. Abortion is essentially a medical term. It's the doctors who have to control it. That effectively, we're going to change the scope of what constitutes abortion. So it's an ectopic pregnancy, a fetal termination because of an ectopic pregnancy that will kill the mother. Is that an abortion? No. Miscarriage. You're carrying a fetus that has ceased to have any life in it. Is that an abortion? No. There are all kinds of ways of redefining, right? So that's a possible thing to do. Another possible thing to do, and we've already seen this from the private sector, is that companies and insurance companies can offer compensation to all of their employees nationwide for transportation and other support to undertake medical
procedures, yeah, where
right,
it's
right,
not available. If it's not
right.
available in your
Which is,
state,
and
then
so
they
you
should
can go, right?
provide.
And we do this all the time with
Yeah.
fancy bone marrow procedures, or,
Mhm.
I have to go to the Mayo Clinic in Minnesota and I live in South Carolina, and, that's no problem. Well, now I can't I can't terminate my pregnancy in Mississippi. Fine. I'll get paid to go to New York. And that helps now middle class and upper middle class women.
Yeah, and then hopefully there will be support from those insurance companies who have to shell over extra money.
Right, or the companies themselves. But there's all kinds of other things you can do. You do freedom buses. Where's the NGOs when you need them? They some
I
of
think
them
that's
should be
already starting to
litigating.
happen in a few
Right,
states.
right. Some of them should be litigating, but there should be a huge drive now to make bus services available, because the people, it's the underserved community that you're worried about the most.
Yeah, women
Middle
were
class
cut
women could
off
fly to New York. A poor woman can't.
procedure.
Right, right. Yeah, no, I heard about that. And you get buses or airplanes, you get subsidies. You ask airlines to donate seats, so that, as part of their charitable contributions, to donate a seat for women's health things, as United, Delta, or other airlines can do this,
Mhm.
right? So there's all kinds of things that are likely to begin to happen that may undermine this. The other thing you can do, right, because there's all kinds of things that are going on. So one of them is, and all kinds of issues can, which is why this may unravel. Can I, if I'm sitting in Mississippi, and let's say Mississippi law says you can't administer any kind of abortion-inducing thing in Mississippi, can I order a morning after pill from New York and ingest it in Mississippi? Am I liable as an abortion performer because I took the pill? And can Mississippi reach out to the company that sold it to me in New York? That's an issue. Justice Kennedy or Justice Kavanaugh said, don't worry about women traveling to New York. That'll be okay. Again, the court is very middle class in origin because that's what they know. And that's where they're thinking about.
Yes,
but,
everybody can afford a big trip.
Don't worry, ladies. You can go to New York and take in a Broadway show or whatever.
Yes, go shopping.
That's really disgusting. But the mentality. But it's the at-risk population, the poor population, and so you need to deal with that. But another thing that's going on is the question about speech and inducement. So one of the things that and here the Democratic Party has really lost an opportunity. It would be very interesting, for example, to have the Democratic leadership, starting with Mrs. Pelosi, to go down to Texas and begin holding rallies, for example, to induce the people of Texas to insist on having a constitutional referendum in Texas to preserve the autonomy of women.
I think they're way too scared. I don't think this Democratic Party is.
No, but but those kinds of things.
It would be fabulous to see that.
Right. The protest and the anger is important to some extent, but it's a short-term emotive thing.
Yeah, we need action. We need
workarounds. You need political action, but you also need
legislative.
But we aren't a Marxist-Leninist state. The heart of this country is not in the public sector, and we forget this. It's in the private sector. And if you can't mobilize the private and social sector to end run this, the way, for example, the anti-slavery movement did, the way the gay rights movement did, if you can't mobilize the private sector to protect and explode this thing, then you're out of luck. I think the case is here for a while. I think that the case has, of course, a lot of problems or a lot of choices, but there's a lot of anger here. There's a lot of anger. It's one thing when you have a decision that gives a woman a choice, but protects a woman who absolutely fundamentally believes against abortion, doesn't affect her at all. Here it's the reverse. So unlike Roe, in this case, women who oppose the particular view now have no choice, right? So there's an actual imposition. This has a positive effect as opposed to a negative effect, and that ought to have consequences. So what else about the case? Views.
What do you mean? What else?
Well,
it's
besides being angry, I mean, this is a kind of case that ought to energize. Um,
right
and
there. It made me immediately want to go and review previous precedents. Um, I mean, and in a catty way, of course, review the Loving versus Virginia.
oh, well, that's right.
Um,
Oh, yeah, right.
because
And
how dare you? Honestly, in my view, how dare you jump to dictate someone else's liberty
well,
when
and that brings up the bigger question. Why is it that we're more than happy to give the state the authority to muck around
why is
in
that
social
okay?
relations?
I was appalled when I read those sentences that said, it's totally cool to give it up to the states to do whatever they want with a woman's body. I know it didn't say it like that, but it absolutely read to me like that.
No, it's not just that. It's all social relations, families, um, uh,
Family
everything,
planning. Yeah, let the state do that for you.
children and the like. There's some reasons that the state ought to intervene, but you've got a long tradition of either the church, and I don't mean just Western churches, but all kinds of churches, of some collective controlling social relations. In this advanced age, one ought to think through rather than to just accept whether to what extent the state ought to have any business in dealing with these social relations at all. It's a discussion that we don't like having because we're comfortable with, I guess it's inertia.
I'm not comfortable with it. Any ruling that takes away some sort of personal.
Right, but that's a very modern view. That's a very modern view. 100 years ago, the opposite would have been the starting position, but it shows you how society has advanced.
Which is
and
why we need
has advanced, right? We ought
to
to
help the Constitution advance with society. You know what I mean?
Well, but that requires constitutional discussion. And the one thing this country, as divided as it is right now, does not want to do.
Well, that's what we were made for. We're made for discourse.
Discord or discourse?
Both. We're Americans.
Oh, good Lord. Well, but no one wants to do this because by no one, I mean anyone with the power to do this. And plus, you're going to have to deal with a bunch of people that are going to make you angry. And can you hold your temper enough to create a compromise document that we can all live together on some basis of shared solidarity? That becomes the hard thing because at the end of the day, what we've all forgotten in this crazy frenzy of identitarian politics, of ideological basis for everything, is that the nation is built, and this republic certainly is built from a bedrock of at least some amount of solidarity, some consensus around some core values. And if we don't have that, then the conversation is going to become much more interesting.
Well, most of the polls for the public, the general public, at least 64%, 60 some odd percent, believe that abortion rights should be totally available for women.
Sure. And in 1920, probably 70% of the population
it would have been
against.
The opposite, but we're not in 1920 anymore.
And so what if in 2070, 70% of the population thinks that abortion is horrible?
What if in 2070, everybody thinks slavery is great?
Aha, that's exactly right. And so you worry about these things. And one of the reasons why you have a constitution is to put limitations on the ability of a population to give in to either baser instincts or to go beyond what we believe to be the core of those. Again, we go back to this foundation of solidarity that distinguishes us and holds us together as a people around a set of core values, right? But that's a discussion. But like you said, it's a core, and then around it, there can be a lot of dynamism. Slavery is certainly, hopefully, will remain off the table. The equality of women should also be off the table. That are questions about that, et cetera, et cetera. There are a number of things around which you can build solidarity, and maybe a focus on that rather than on the fine tuning, with a lot of faith in people to be able to exercise all kinds of difference without undermining the solidarity of the Republic is the way to go right now. But yeah, that's sort of the problem. But where the state, in fact, and ironically, of course, the court is basically taking a sort of similar position. Oh, and this is Kavanaugh again. Oh, and Alito to some extent. This issue is still very contentious. I don't know. This woman autonomy or fetuses, it makes us crazy. There's no real consensus. We don't have any consensus on anything, but that's all right. In this case, this is the one we want to highlight. And so what we're going to do is say, we're going to stay out of it, and we're going to let politics rule. And if that's the case, and I think, to some extent, that's the silver lining here. And that is, if in fact we can be weaned from a dependence on the serendipity of 5 people making the right choices, if we again take back politics.
It seems like that's the choice that we have to make right now.
Right, but that means we have to get up, or everyone, which is effectively what the anti-abortion people did over the course of 50 years. That will require people who have a particular view of women's autonomy, especially in the context of pregnancy. It's going to require them to get off their chairs, to stop relying on a master or an elite or a priest to somehow protect them, and to take their fates into their own hands. And that is something that people who are used to suckling at the teat of the state are no longer very good at doing. And that's a slap at the people who are sitting and moaning about this case when they knew it was coming, or the possibility of it coming, and who were not ready, since everyone's been talking about how certainly since after the Second World War, the court has become more and more political as we've constitutionalized virtually everything, or potentially constitutionalized virtually everything. It really did point to the idea that we now have a political constitutional court, which is not a bad thing, but that because it's political, we should stop thinking about it as sacred, going back to your idea of the Constitution as the Bible, as Holy Writ, and the judges as our high priests.
Right.
We should get over that and understand that this is politics.
Yes.
And we should be as respectful of politics and political figures and their judgment as we have been of certain presidents, certainly since the turn of this century. Yes. And that's probably the next step. So, which is why I took the position, yes, 213 pages of obtuse stuff. I love reading obtuse stuff, but it doesn't do the Republic any good. And it certainly doesn't do our social order any good if a person with a 6th grade education can't read this and understand what's going on in her country. And that means you got to take it back. And you got to take it back with the levers of politics that the Constitution has given you, and which liberal democratic theory has vested in you. As Benjamin Franklin said, you have a republic, keep it if you can. And now let's see how people keep things.
Let's see how long we can keep it.
Well, by we, I mean this faction. But remember, there's another equally fierce in their views and determination factor who are also seeing this politically, and who will also be moving every lever at their disposal to control politics. And that then, here's the great irony, brings us back to the fundamental question. if you've got two hugely contentious factions that are going to rip us all to shreds? Should we not find a way of making peace that will keep everyone more or less happy, or happy enough to be united, at least for a little bit of time? We did that. And every time we've done this, it only lasts a little bit of time. They thought they were doing that with slavery. They thought they were doing that after slavery with the kind of laissez-faire of the post-Civil War period. They thought they were doing this with the welfare state after the 30s. And these consensus work, but we have to understand this, picking up from your point, that people have a way of dying. And so what worked really well for a generation born in 1900 may not be so cool for a generation born in 1980.
Things change.
Right, but that also means that politics change, fundamental views change, and you're going to have to be ready for a rollicking
to adapt. But it seems as though the high priests of the high court don't understand the adaptation.
Well, my answer to that is you give them as much power as you give them.
Exactly, which is infuriating.
You've given it to them, you've elevated them to this quasi-holy status. You can defrock them as well. I, for one,
speaking of defrocking, so if, for instance, when you were confirming said judge, and they said something like, for instance, that they wouldn't overturn a said precedent, but then they did.
Well, they wouldn't overturn a said precedent given the facts and the context in which things existed at the time of their confirmation.
Oh, so you're going to lawyer.
Look, no, if you're going to go down that road, then virtually every justice that has ever been appointed should have been impeached. The prime example of that, just to go back, is Justice. No, you all, that's what I love about Americans. History starts 10 years.
Yes, tell me, I want to know.
Justice Brennan from the 50s. Eisenhower chose him because he thought he was a nice, conservative, middle-of-the-road justice. And then he turns out to be one of the great horsemen of the liberal revolution of the court in the 60s and 70s, and I think early 80s. And the Republicans who had nominated him were flummoxed. What happened here? And so they pulled a Susan Collins saying, oh my God. So no, this happens all the time. And it's, again, this is this high priest thing. A justice, the appointment of a justice is a political thing. It's not the equivalent of granting someone tenure on the basis of academic work. And even that is riven with politics. This is a political thing. They are meant to be, this is where politics starts and ends. So why people get all bent out of shape when the process of choosing a justice is political, it's meant to be political. Their work as a justice is not, but their choice certainly is. So, but again, that makes them both human,
because they spend all of their time during that process trying to convince everybody that it's not.
That's on you. That's on you. I can also try to convince you that I've got a bridge to sell you somewhere in New York. The more fool you for having agreed to the construction of this fantasy around this mythical judge priest. The way in which you have this mythical fantasy about a president who is nearer, my God, to thee, and elected officials who somehow have the aura of the one true and living God that tends to create some auras around them that make them different from you and me. They're human beings. They ought to be treated as human beings. They're flawed. They make mistakes. They are subject to the same venalities, pressures, and limitations as everyone else, and they need to be reminded of their humanity constantly and then held to account. To treat them or their expectations as some kind of God king or God emperor or some kind of pope or patriarch is that's on us. You created this fantasy world and then you're disappointed, and I've got no pity for you. That's your own fault, and you've built this funeral pyre and these folks in the Dobbs case have just lit the match, and now you're wondering why it is you're tied up and you're smelling smoke all around you. Well, get off the stake, get off from under the stake, get off the pyre, and start doing stuff yourself.
Yeah.
And that's all I got.
Yeah. I mean, this just makes it clear to me that we have to use Congress for things that we really care about or that we really feel strongly about.
That's why, again, it's this dependency on the state. Or maybe you all set up collectives and you deal with this stuff without having to deal with our masters, our alien overlords in Washington or in Austin.
When you feel like it's
okay,
this is why, because you always feel like you're going, if I feel like my body is always going to be legislated by somebody else, that's why I feel like I need to get protected by
agreed
something bigger.
Yeah. No, agreed. But other than that, this is not a vanguard-driven state. It is a state that in which the apparatus of government is meant to serve rather than guide. We forget that at our peril. If we want a vanguard system, we've got lots of models. Some of them have worked, some of them have not worked, but that's not our model. And yet we mew as if it were. And that's really part of the problem. And again, that going back to the decisions be the last thing I say, I think. And that's the problem with decisions like this. We invest so much in it and them. We give it such weight that we forget for a moment that these are merely judges exercising a judicial authority to resolve disputes, including their specific interpretation, and that other bodies, both public and private, have as much right to live the constitutional understandings as the court does.
I'm just going to look at court rulings as ridiculously ephemeral now. I'm not going to take them as seriously as I once did.
No, they're still quite potent. You
of course they are, but they're not as staying as they're tools, just like anything else.
Right, and you can, or actually they are, you're going to the grocery store, they've given you a cantaloupe and you like bananas, or they've given you a cantaloupe that is rotten. These are bad analogies, but anyway,
they're terrible.
All right, so all hail the court, all hail Dobbs, all hail us as we bend the knee to our judicial overlords.
Yeah, right. Yay.
Yeah, and the more fool us, especially when we wind up in a kind of situation where very few people on earth are now privy enough to the internal workings of this and to its manipulation, strategic manipulation, that they have to some large extent really stripped the American population of any effective means of engaging in the kind of constitutional conversations that we ought to be having. And we have delegated our freedoms to a bunch of lawyers, judges, and academics who now exercise the role of democratic governance in our place. And that more than
our
anything
representative.
That more than anything else should horrify the American population, as divided as we are. But on that happy thought, it's now, we've had action. That's the Dobbs case. We are now going to have reaction. Let's see what happens. And probably reaction to the reaction. The games will have begun.
They have begun.
Sorry, the politics will have begun.
Which is games.
Woof, woof.
Bark, bark. Thanks for listening, everyone. We will catch you next time.
Sorry it was so long.